Um, Getting back to part two of the series, where I'm gonna continue on pointing out the injustice and wrongful conviction that occurred in my case in Madison County, beginning April 19th, 1999, on up to my trial beginning on January 22nd, 2001, in Madison County, Alabama. I had started out yesterday giving a brief overview of some of the issues that I'll be covering in my case, and we're going to go back today and take a more in-depth look at some of the documents in the case, look at some of the transcripts, some of the files. The first issue that we're dealing with is the ballistics evidence in my case, and we're going to it runs very closely with medical evidence dealing with the cause of death. So we're going to go back and forward on those, but primarily this will be about the ballistics report, and then we'll transition to the cause of death, the two causes of death, the two autopsy reports, the two pathologists, the two indictments, the two grand juries. We're going to go into that immediately following the ballistics information. As I pointed out yesterday, I was convicted January 2001, for the murder of Mr. Andre Horton. And what I'm going to show you right here, this is the first indictment that was passed in my case. And you can see right here it says that Mr. Horton was intentionally killed by asphyxiating him by placing a plastic bag over his head or other means unknown to the grand jury. This is what I was originally indicted for. This indictment was handed down. Let's get the date on this indictment. This indictment was handed down in May 2000. Some point after that, the prosecutors in the case decided that they wanted to re-examine the cause of death, and they filed what is called a motion to exhume. And this is the motion to exhume right here. And they filed that stating that this is what they said: the follow-up investigation revealed information that the victim was shot in the back of the head. And so with that, the body of Mr. Horton was exhumed. A second autopsy was performed, and the cause of death was changed. At the time, the prosecutor was stating that this new information had came from the co-defendant, Fred Batts. I showed you that yesterday. You see right here, this is a letter, an email from the doctor, Stephen Postilny, who is the doctor that performed the original autopsy. He said, when the DA in Madison County spoke to me some months after the autopsy and stated that he had two defendants, one of whom was adamant and unswerving about the other guy shooting the deceased. And so this is allegedly where the information came from that led them to conduct a second autopsy, exhume Mr. Horton's body, and at that time they saw the second pathologist, Dr. Postilny, who had performed the first autopsy, was not the doctor who performed the second autopsy. And so I didn't find this out until after trial. I was able to locate Dr. Postilny after trial. And they exhumed the body, went back in, and came with a second indictment. And here's the second indictment here. As you can see, it says that they charged me again. The grand jury did intentionally cause the death of another person, Mr. Horton, by shooting him with a pistol. So at this time, the cause of death has changed, and this indictment was passed down December 8th of 2000. So you had one indictment by the grand jury passed in May of 2000. Then you had a second one that was passed down in December. As I said, the second autopsy was performed by Dr. J.C. Upshaw Downs. And the attorney, the district attorney, Mr. Robert Lee Brazard, was telling us that this information about the second cause of death came from the co-defendant, Fred Batts. And so he went into the exhumation hearing. That's what he told the judge. That's what he told my trial attorney. That's what he told me. He said that this information had came from the co-defendant. And I'm fixing to show you right here where my attorney is saying that he was told this by the district attorney, Mr. Brazard, also. Now, what had happened is during the course of my trial, during closing arguments, the prosecutor was attempting to tell the jury that the information about the second cause of death had come from the co-defendant. And the problem with that is that when the co-defendant came to trial, he was asked, he said, when did you first sit down, not talking about the videotape we just saw, putting that aside, when did you next sit down to talk to the district attorney's office and investigators about the facts or what you contend are the facts on March 24th? About 2 weeks, a week or two, about 2 weeks. About 2 weeks ago. Yes, sir. So between March of 99 and today, which was January of 2001, you had interaction with the folks from the district attorney's office with the sheriff department. That would have been 2 weeks ago, yes. And the purpose of that interview with them was to give them what is called a proffer of what you might say in court today. Is that correct? This was the purpose. Yes, sir. Okay. So what he's saying here is that from March of 1999, the next time that he sat down with prosecutors was in January, approximately January the 8th or the 15th. He said a week or two. The trial began January 22nd. So he said the next time he talked to him was 2 weeks before trial began. And so at that point, it became a question of, okay, well, if you didn't talk to him around the time that the motion to exhume was filed, then where did that information come from? And so that is what the issue was at that time. We were trying to figure out, okay, where did this information come from about the gunshot? Because you just saw for yourself that Bat stated that he was not in communication with the prosecuting office during that time. And so right here on the record, you'll see my trial attorney, he was posing an objection. And what he was objecting to was that the prosecutor was attempting to tell the jury that this information about the second autopsy, the gunshot, had came from the co-defendant. But you just saw yourself, the co-defendant said he wasn't the one that was communicating with him at that time. And so here's where you'll see where the prosecutor, Mr. Brazard, told my attorney the information came from Bass. You've already saw where he told the first pathologist that it came from Bass. And here it is. He said, at one point, Mr. Brazard stated to the jury or suggested to the jury that the reason a second autopsy was done was because Fred Bass provided the state information about the gunshot wound. That evidence was never put before the jury factually. What occurred, according to defense counsel understanding, is that Mr. Lampley made a proffer to Mr. Brazard, and that proffer was part of the reason why the autopsy was done. Not disputing that occurred, but that evidence was never put before the jury. He says, important piece of evidence is corroborative of Bass, but it was never put before the jury in any testimony. Indeed, the contrary. Evidence was suggested that Mr. Bass testified on direct and cross that his corroboration phase began several weeks ago. And he testified that his first meeting with the district attorney's office happened several weeks ago. That's what he testified to. So we're now trying to figure out, where did this information come from? And it's clear at this point that it did not come from the people who the prosecutor had told us. And so what happened is, after my trial on post-conviction, and I found out that we had been lied to, I filed what is called a Rule 32 post-conviction petition. And in that petition, I alleged that the prosecutor had committed misconduct in that he had provided us this false information to justify having a body exhumed. And so the state changed their position. This is what they changed it to. This will be the brief of the appellee. The appeal number is CR-02-1766. You can view that in the Alabama Court of Criminal Appeals. It'll be under the brief of the appellee, which is the state. And this is what they changed it to. They went from saying that it came from bats to this. They said, Dr. James Downs, the pathologist who conducted the second autopsy, testified that his interest in re-autopsying the body was the result of inquiries made by Huntsville area law enforcement. These law enforcement officials related that they were receiving information from the street contradicting the original autopsy conclusion that Horton had been asphyxiated. They did not specify from whom the information had came. They did not have to. But that's not what Mr. Brazar said when he sought to get the autopsy. That's not what he said. He said that the information came from Fred Bass. And you have already saw that. He said it came from Fred Bass. That's what he told us. That's what he told the trial court at the motion to exhume hearing. And that's what he told the pathologist who had performed the original autopsy, that the information had came from the co-defendant. I've already showed you that. I'm going to pull that email up again and show it to you again. Give me just 1 second, and here's the email. Because again, this is the email from Dr. Pastilli. When the DA in Madison County spoke to me some months after the autopsy and stated he had 2 defendants, one of whom was adamant and unswerving about the other guy shooting the deceased. Nothing in there about people from the street. Totally changed. Totally changed. And to this day, they still not told me who these people from the street are. They haven't told me who they told, which officer. They haven't told me what they stated. I don't know nothing about these people. As I stated, Dr. Pastilli performed the original autopsy. So this is the person who the prosecutor contacted. And this is his report. This is his report right here. This is the report performed by Dr. Downs. Cause of death, asphyxiation due to exclusion of oxygen, homicide. And I'll show you his signature right here. August 3rd, 1999, Cooper Green Hospital, Stephen M. Pastilli. Asphyxiation. The state goes back, changes that, and says something different occurred. We want to know, where did this information come from? And they're not willing to tell us. They went and got a second doctor, Dr. J.C. Upshaw Downs, autopsy of Andre Horton. He comes back and says something totally different. He says this man died as a gunshot wound to the neck. But I want to point out something in Dr. Pastilli's report. Now, this report was done August the 22nd of 2000. Mr. Horton was killed in March of 1999. So you're talking about March, April, May, June, July, 17 months later. And this is what Dr. Downs said. He said, internally, the wound passes through the soft tissue of the neck. Fresh blood is associated with the wound tract. So what he's saying is, 17 months later, he found fresh blood when he performed the second autopsy. 17 months later, fresh blood was found, according to Dr. Downs. Fresh blood. Now, how they could find fresh blood 17 months later, I don't know. I'm not an expert, but I'm not a fool either. And so I highly doubt that he found fresh blood 17 months later. This was not the only time this became an issue. My jury, during their deliberation, they stopped deliberating and they asked the question. They wanted to know, where did this information come from? Now I want to take you back just a second. This is on my direct appeal. Now we were arguing that the prosecutor had committed misconduct in the trial by saying that they were at trial. They were trying to tell the jury that the information came from bats, and this is what the court said. Thus, it is a reasonable inference for the state to argue that Bat's statements were the reason for the second autopsy to determine if Horton's death had been caused by a gunshot wound, and thus the trial court did not abuse its discretion in overruling Ray's objection. In other words, what they're saying is, when the prosecutor was at trial lying and telling the jury that this new information about a gunshot had came from Fred Bass, they're saying that there was nothing wrong with that. But we saw that now they're saying it didn't come from Bass. So we know that the prosecutor is lying. We know that he's lying about where this information came from. Now, this is during jury deliberations. This would be on Thursday, January 25th, 2001 at 3:30 p.m. Courtroom number 6, appearance. They said, all right, good afternoon, ladies and gentlemen. I have been giving a document containing 2 questions submitted by the jury, and that's a proper way to do it. If you have a question you cannot resolve, you should submit it to the court, and if I can address it, I will do so. Some things I am not able to address. He says, there appears to be 2 questions. The first question is, who informed the investigators or the district attorney that the victim had been shot in the head? I have conferred with counsel as I am required to do concerning this, and upon doing that, it has been determined that there was no submission into evidence pertaining to this particular question. Therefore, if there was some reference or comment or statement made by counsel pertaining to this particular issue, then I will remind you that comment or statement of counsel are not evidence. So, why is the prosecutor trying to tell the jury that this information came from Batts when Batts has gotten on the witness stand and said that he didn't provide it? And why is the prosecutor, why has he told the judge, why has he told the first forensic pathologist, why has he told my defense counsel, why has he told me that the reason why he wants to exhume Horton's body is because the second co-defendant, which was Batts, had provided them this information, and we get to trial and find out that Batts did not provide the information. And then when we expose this lie, he then changes it and says, what? Law enforcement officials related that they were receiving information from the street, contradicting the original autopsy. Again, what law enforcement officials? I challenge anyone to go to my trial, go to my court, get my transcript, and find out if any law enforcement officer got on the stand and said someone contacted them. Not a single law enforcement officer who testified in my trial testified that they were contacted by anyone. All of us were told that this information came from Fred Bass and that he related directly to the district attorney's office. You saw my attorney stated in his objection. You saw the forensic pathologist stated in his email. You saw it in the motion to exhume. You see it over and over and over that the prosecutor is saying that Batts gave this information to him. This is what you saw this already. Stated that he had two defendants. That was me and Fred Batts, one of whom was adamant and unswerving about the other guy shooting the deceased. Well, that's not all Dr. Postilnik said. Here's something else Dr. Postilnik said. He said, I stand by my conclusions. He said something else. And this is what I find very interesting. He said, again, Dr. Postilnik, he said, if you want to investigate the other pathologists, start with the district attorneys in the state, all of whom, along with the attorney general, supported a bill to fire him. I have no animosity toward the DA. They were duped by him as well as the rest of the state. Now look at this. Your client's first defense team should have realized the game being played and not have allowed it. We were having difficulty contacting Dr. Downs, and we thought he was trying to avoid us, and that's why he was making the comments that he was not. He didn't want. He was asking what is the purpose of the threats, and the threats were that she was going to take further action to try to get him to explain to us what was going on. And you saw what he said. He said that as a matter of fact, I'm going to show you the email that she wrote so that you will know exactly what she said, if I can find it. Okay, here it is. She says, it is imperative that I speak with you in regards to Melvin Ray's case and your autopsy. If I can't get the information directly through you, I will be left with no other choice but to pursue other means of investigation into your background as well as the background of the other pathologists. I cannot imagine that you wouldn't want to stand up for yourself as the district attorney stated at trial that you have blown it, and yet you were not given the opportunity to be present and defend your findings. If you are not willing to submit an affidavit verifying the findings of your autopsy report, please advise me so that we may take the necessary measure. And that's what he meant when he said, what is the purpose of the threat? My background is not a secret, nor am I ashamed. I have been challenged several times in court on other cases where the Horton case was brought up and an ad hominem attack. None were successful. And so that's when he said your client's first defense team should have realized the game been played and not have allowed it. And so we're still trying to find out what is the game that was being played. And we know part of it is that they're lying about where this information about the gunshot came from. And so we're still on that trail. And so when we get to trial, and supposedly there is this evidence that this man was shot, well, we want to know, what does this evidence say? And this is what Fred Bass said at trial. This is what Bass said at trial. He said that I had two guns, a .357 and a 9mm. And he said that the 9mm is the one that I had used to kill Andre Horton with. I showed you all yesterday the reporter who was at the trial, David Holden of the Huntsville Times. This is public record. Anybody can look at it. Fred Bass said, according to Downs' testimony, Postilnik ignored the hole in the back of Horton's head where a 9mm bullet chipped the skull. Now, let's talk about this 9mm testimony for a minute. Okay? They're saying that Mr. Horton was killed with a 9mm. All All right, you saw the reporter David Holden, who was at the trial, reporting this is what's being testified to by the doctors at trial. This is what Bats testified to. Okay, uh, and so later on after trial, once I began investigating my case, I wanted to know where's the projectile. Where's the projectile? Where's the bullet? It never came in court. Dr. Postilny, the doctor who performed the first autopsy, the state never subpoenaed him to court. We never got a chance to speak with him. Never got a chance to hear from him in a trial. And so we're trying to find out why is it that they're alleging that this change of death, changing the cause of death, changing the evidence, but no one's in court to testify to it. And so what did we find out? This is what we found out.